There's never a good time to leave a litigation job. Trials, motions, deadlines are literally always approaching. That's what you and your team are presumably paid to deal with. And firms, take it from firsthand knowledge, expect turnover. Welcome to Office Hours, folks. Today we are taking listener submission questions. I won't keep the content from you, but if you have a question you want to ask, please email questions@thyme.org. That's questions@thyme.org, and we might feature your question, your topic, your discussion on the show. Let's get into it.
Hey John, quick gut check question here. I've got a potential move in front of me that's a big step up, but the timing's awkward. I'm pretty involved in a case that's getting close to trial at my current firm, and if I take on the new role, I need to transition sooner than I ideally want. I like the people that I work with and don't want to put anyone, especially the client, in a bad spot. I'm trying to think through what the right way to handle something like this is so I don't burn bridges or leave a mess behind. Curious how you'd think about that if you were in my shoes.
Oh, that's a fantastic question. So first, some ground rules. It sounds like you're at a larger firm, or at least a mid-sized firm, because you seem to have a team and you seem to have some infrastructure around you. When people reference they love the people they work with, they usually mean their coworkers, their paralegals, their staff. It's awesome you have that in mind. There's never a good time to leave a litigation job. Trials, motions, deadlines are literally always approaching. That's what you and your team are presumably paid to deal with. And firms, take it from firsthand knowledge, expect turnover. You should give notice quickly once you accept a new offer, which it sounds like you have on the table. Congratulations on the step up. That's the most respectful and professional route. But beyond that, your ethical duty is to the client, not the firm. As long as you give the notice professionally and are respectful and don't play games with anyone on the board, you should be fine. Leave the case organized for a smooth handoff and make sure you brief your team on everything that's going on if you have special knowledge about the matter. And expect the possibility of being walked out immediately. We do this. It's not because we're mad that that you're leaving. It's because we can't have someone who is very soon going to be out the door learning anything about the client files. So it's usually just best to just be ready to respectfully be walked out the door. There's not necessarily anything wrong with that as long as they handle it professionally. And know that in some very limited instances, offering limited assistance after you leave, as long as there's no conflict issues, is an option if both firms agree. People change jobs all the time. I honestly don't understand why we in the legal industry make such a huge deal about changing jobs. As long as you've been there for a year or two and you haven't done anything crazy and no one thinks you're a psychopath, your reputation is going to be just fine. This is a job market. It's a labor market where you sell your time and your employer buys it hourly, salary, or on commission. Equity holders that make you feel like it is a personal transaction are deceiving you. Now, that doesn't mean you don't care about them or that they don't care about you. But remember that there will always be an associate after you and there will always be an associate before you. So don't get hung up on the right thing when your firm would probably throw you under the table, under the bus, under the jumbo jet at the first opportunity. Congratulations on the new job. Like and follow the show if you're enjoying it, and we'll be right back. Support for the show comes from LegalRev. They don't just market law firms, they grow them. With smart SEO, Google Ads, web design, and AI-ready search strategies, they make sure your next client finds you first. If you're ready to win online, go to LegalRev.com/factor. That's LegalRev.com/factor. And now to continue the conversation.
John, after going solo, my main focus has been keeping overhead low while still having systems that I can trust. I've built a pretty lean setup that covers the basics: case management, billing, documents, payments, research, and staying paperless. And overall, it's been working well, but I'm starting to think more about optimization and whether or not there are tools and workflows that solos tend to overlook early on. In particular, I'm curious about ways to improve efficiency, cut down on billing leakage, streamline intake, or identify things that are commonly overkill at this stage. From your experience, what should someone running a solo practice be thinking about adding, rethinking, or simplifying?
Oh, this is a fantastic question. Now, first off, if it was a relatively recent event, congratulations on hanging a shingle. It's a huge deal. The risk arbitrage is that you are going to make more money than you have ever known before as an employee, but the downside is that you are also exposed to way more risk. I'm hoping that trade-off has been favorable for you, so congratulations for the leap. First thing is payments. Payments is the biggest thing. Most people use Clio Payments or LawPay. They're both cheap. They're already fully integrated with many practice management systems. They both offer all sorts of basically and soup to nuts white labeling on their payment processing. They take everything from Apple cards to MasterCard, Visa, Amex, bank accounts, wire transfers. If anyone has money, both of these systems will find a way to give it to you. And even if they don't have money, they even offer payment financing, payment plans. So you get paid up front for like 10% of the fee, and then the client pays back LawPay or Clio or Affirm through Clio over time. So it's a win-win. To address collections, I would just recommend shortening your billing time, which is to say if you are B2C, bill every week instead of every month. That does two things. One, it prevents sticker shock when clients get ambushed at the end of the month with huge bills. So shortening it to a week reduces that. Second, if a client is a deadbeat, regardless of the number, you'll find out almost right away instead of at the end of a month after you've done a ton of work for them. Some other attorneys do recommend alternate processors like Confido or No Rate for lower fees and financing options, but I think that's the wrong question to ask. I don't think you should ask, what does something cost? I think you should ask, what will something get you? Because there are plenty of completely free options that work terribly and that will take a ton of time to maneuver. They are free, but you pay for them in the time and clunkiness and a million other paper cuts that take away from their utility. For PDF and document tools, don't overthink it. Adobe Acrobat Pro remains the gold standard for redacting and bait stamping and doing everything else with PDFs that you may need in almost any practice area. There's some strong alternatives like Foxit PDF Editor, PDF Gear, or PDF 24 for light, free PDF tasks, and Power PDF for those who want a non-subscription model. But Adobe, it's fantastic. It integrates with everyone's systems. It even has e-signature functionality. Something to keep in mind. Legal research alternatives like Vincent AI with Clio, Open Juris, Co-Counsel, Protege, or Bar Association provided Fastcase, which is here in Washington State that they have an agreement with Fastcase, which is awesome. AI assistance, this depends on your practice area, but Eve, Legal Document Summarizer, or Demand Drafting AI with manual review, if that is something that makes you feel a little bit better. I wouldn't recommend AI assistants because they can multiply your output, but only if you have the manpower and time to review everything they do. Otherwise, it will cause you more problems than they solve. So if you have an assistant and a paralegal that you trust, bear in mind that it may be helpful, but tread carefully otherwise. Text expansion tools like Text Expander, TextBlazer, Esponzo are good options. Again, depends on your practice area. Moving on to hardware or practical tools, unlimited hotspot for courthouse with bad Wi-Fi, you're going to need a good cell plan. If you are transactional, then maybe not, but if you do field work, you're going to need a really good bandwidth plan on your iPhone. It's usually just what I recommend to my team when they're in the field. You should get multiple monitors. Studies show that you are at least 37% more productive if you have a large or multiple monitors. That's why we insist that everyone work on multiple monitors, whether or not they want to here at Hemmett Law. 20% of the staff come in and they're like, no, I work great on 2 monitors. And then we check the logs after their first month and they are slower than everyone else. We make them set up another monitor, get it all nice and pretty for them, and they always work faster. So 2 or 3 monitors if your setup allows. I also recommend a reliable scanner. Now, we use Raven Scanner until they went out of business. So now ScanSnap, the IX1600 is like a community favorite and they are still being produced. So general takeaway is look to the eyes of what a system solves. I see this in solo practitioners all the time. They're like, what does it cost? What does it cost? Wrong question. You should ask, what does it get me? Right? If I had a tool that was guaranteed to make you $1 million a month and I asked for $500,000 to rent it to you, you would find a way to give me $500,000 a month because you're guaranteed to make $1 million. So I would challenge the preconception that cost equal bad. What happens is people fall into that trap and then they spend all their time caring so much about the dollar amount that they never put any money or energy or time into process efficiencies that may cost more, but get them more money in opportunity cost, time saved, problem solved. Congratulations on hanging a shingle. Go kill it out there. I'm sure you're going to do fantastic. Thanks for the question. We'll be right back. Support for the show comes from Thyme. Thyme captures every billable email on cases and turns them into client-friendly time entry descriptions completely hands-free. No more lost time, no more pre-billing reviews, just up to 30% more revenue. Get a free demo at thyme.org/factor. That's thyme.org/factor. Thanks for your patience. Welcome back.
Hey, John, I've been thinking about this as a bit of a thought experiment and wanted to get your take. Hypothetically, if you were min-maxing your legal career from day one with the goal of going solo, what path do you think makes the most sense right now? I feel like PI is always the default answer in these conversations, but I'm not convinced it's automatically the best or only way anymore, given how the profession's changed. Curious how you would be thinking about it if you were designing the game plan from scratch. Would love to hear how you would theory craft it.
Oh, thank you so much for the amazing question. This is a great question. So first off, I think it depends on what you mean by min-maxing. So I'm going to assume maximum money for least effort, right? Because everybody, I could min-max for lifestyle. I could be like, I never want to come into the office, more than 4 hours a day. Or I could come in, 2 days a week. And there are fantastic practices that are usually transactional or seasonal that do that. Not for me. So I'm going to assume, you're calling into a growth-minded podcast. I'm going to assume you mean maximum volume at minimum effort. You got a couple of options. PI really is the best from a risk arbitrage upside perspective, really is the default for a reason. All the wealthiest attorneys are PI attorneys. Full stop. There's no way around it. All the biggest, most successful businesses, PI attorneys. And that's because there is incredible upside. You get the right case on the line and then you make $100 million from it, 2 to 8 years later. That's a fantastic arbitrage, almost no matter how you look at it. I am in family law because we sat down and we realized that because of that upside, family law firms are not serious about marketing the way PI firms are. All PI firms, it's ruthless competition for those leads, $1,000 a click in some of the biggest markets in the state, or in the country. And unlike PI, which is sort of feast or famine, you got to hit those home runs. If you don't hit those home runs, you'll just, end up on a small treadmill of, car accident, fender benders, slip and falls that they pay the bills. They keep the lights on. They keep the place running, waiting for the big cases. But they don't make any significant money such that it is worth it. But family law, not the case. Family law is just as ubiquitous as PI, and our competitors don't take it seriously in the same way that PI firms do because they know that upside. So the adjusted competition effort was way lower. And further, we can make a relatively predictable amount of money from every case, which is to say in PI, you bat home runs. In family law or other practices like them, B2C common practices like them, you just bat singles. If you could bat singles reliably, you'll make more money than almost anyone else except PI attorneys, because there's always more business in family law. That's a sad reality. As long as there are two people on earth, someone is going to want someone else divorced. The other thing is, don't do criminal law unless you're in it for the love of the game, because very few, the only people who make any money in criminal law on average are either gigantic firms or the incredibly well-known attorneys that the criminal law attorney that got Diddy off for the metric ton of baby oil. So I would just do what I'm doing now. Bankruptcy and real estate are good options, but bankruptcy and real estate are interestingly tied to the economy in a very direct way. Same with many transactional practices. Even personal injury is not insulated from the economy entirely, because if there's less trucking, if there's less shipping, less economic activity, there are fewer trucking and shipping accidents. Employment law is also another really good area. There's fewer cases than PI, but individual matters can still settle for high numbers. And also, depending on which side you're on, defending the businesses or defending the employees, you can make a lot of money from just putting your name on demand letters. But I'd go with family law. I know that's a very unconventional, roundabout answer, but I love being able to solve problems for people that have problems to solve that are not tied to the wider economic condition. No one looks at the NASDAQ when they decide to get divorced. Whether or not anyone is particularly happy about it, which they usually aren't, and I love being there to help them solve that problem in a moment of crisis. Thanks so much, everyone. This has been Office Hours. If you have a question you want us to feature on the show, email your questions to questions@thyme.org. We are always listening. We're always happy to find good submissions from listeners and feature them here every couple weeks. Cheers, and thanks so much.